Sanbanani, this is the continuation. Kubuka umtsetfosisekelo. Sorry, it's been a while since I got a chance to do the video. Today we'll look to the right to a fair hearing. In the determination of civil rights and obligations, by the way, it's chapter 3. In this determination of civil rights and obligations or any criminal charge, a person shall be given a fair in a public hearing within a reasonable time by an independent and impartial court or adjudicating authority established by law. Section 2. A person who is charged with a criminal offense shall be presumed to be innocent until that person is proven or has pleaded guilty. Be informed as soon as reasonably practicable in a language that persons understand and in sufficient detail of the nature of the offense or charge. Entitled to a legal representation at the expense of the government in the case of any offense which carries a death or imprisonment for life. So that's the only time you will get legal support from the government is if sentence yakho ungahle wehlelwe utsilikelwe jail. That's when you will get legal support. Otherwise, it has to be from your pocket. Given adequate time and facilities for the preparation of the defense, permitted to present a defense before the court either directly or through a legal representative chosen by that person, afforded facilities to examine in person or by the legal representative the witnesses called by the prosecution, and to obtain the attendance of witnesses to testify on behalf of that person on the same condition as those applying to witnesses called by the prosecution. Shoguthi, in other words, a witness le bitwa prosecution or ngulmende ungayi cross-examiner o nawe unalo lungelo lokuletha nawe lotaba i-witness yakakho enkantolo on similar grounds as the prosecutor. Is permitted to have without payment the assistance of an interpreter if that person cannot understand the language that is used at the trial. So get the kaza. 3, except with the free consent of the person concerned, and for the purpose of subsection 2, the trial shall not take place in the absence of that person unless that person acts so as to render the continuance of the proceedings in the presence of that person impracticable, and the court has ordered that person be removed and the trial to proceed in the absence of that person. If also ufuna delay court, case ingaqhubeka without you being present, or if uphele kwenda in a way ukuthi ufuna kudisturb even i-case ingaqhubeka without you, or noma inkantolo ikususele wena for whatever reason ukuthi ube khona, then i-hearing yakho itaqhubeka in your absence. When a person is tried for any criminal offense, the accused person or person authorized by the accused person or your representative shall, if the accused person or person authorized by the accused person so requires and subject to payment of such reasonable fee as may be prescribed by law, be given within reasonable time after judgment a copy for the use of the accused person of any record of the proceedings made by or on behalf of the court. Kuyasho nalapho ukuthi if for instance sephelile iqala lakho sofuna ema-recordings alelo cala, you can ask inkantolo with the payment of whatever fee that you will have to pay litawustipulate ngumtsetfo, then uphole within reasonable time. Reasonable time is subjective ke bazalwane, so please don't send me a message and ask me what do they mean by reasonable time. Reasonable time is based on that person who you don't doubt what do they perceive could be reasonable. It could be 5 years, it could be 1 day, so that's it. So reasonable time is not fixed, subjective. A person shall not be charged with or held to be guilty of a criminal offense on account of any act or omission that did not, at the time of the act or omission took place, constitute an offense. So if ukushaya umthetho lomusha kanti mina ngangaganga, but mangiganga at that time bekungasekuphula umthetho, but mangabe sekushaya umthetho lotawuvimbela ukuthi bagange lokuganga lengikwendile mina and got away with. Mina ngeke ukuthi just because I got away with it last month umthetho ososhayo kule nyanga bese bayangibopha bangibophela umthetho lengiwuphulile usengakendeki loyo mthetho. So umthetho uba applicable from when uba effective. So lo kwendekile before lo mthetho ube in effect, angeke bese kuhamba kubopha bamfu. For instance, let's say njena I don't know ukuthi ngabe kusangane nje. Let's say nje ukuthi umumfu bongambulala umkhanze ejaldeni lakho, khetha wena uthi umendane, bekungasiso isono or kungasilo licala. However, kwabese kuyashintsha kwendiwa licala, wena bakwenda umthetho ukuthi that's illegal. If that kwendeka after wena soke wabulala umumfu, ngeke babese bakujajela sigwebo salo muntu lo wambulala before kube ngumthetho lokho. I hope I make myself clear. A penalty shall not be imposed for any criminal offense that is severe in degree or description than the maximum penalty that might have been imposed for that offense at the time when it was committed. So for instance, if ukuntshontsha mangintshontsha mina bekusho ukuthi ngidawubhadala 20 wemalangeni, but namuhla if ubengingantshontsha but that's kufanele ngibhadale 100 wemalangeni, but because mina i-offense yami ngayenda before kuntshontsha kube ngu-100 wemalangeni, I will have to pay lo 20 wemalangeni. Ngeke bese ngibhadala 100 wemalangeni ngoba pha mina ngaganga i-maximum penalty sengi-20 wemalangeni. But labatawuganga namuhla going forward bona they will be liable to pay lo 100 wemalangeni. Angeke bese bona bese bafuna kubhadala malini 20 wemalangeni because bona bucala babo babende after lo mthetho took effect. A person who has been tried by a competent court for a criminal offense and either convicted or acquitted shall not again be tried on that offense or any other criminal offense of which that person could have been convicted at the trial for the offense, save upon the order of a superior court made in the course of an appeal or review proceedings relating to the conviction or acquittal. Sho ukuthi nje mangabe ngahamba ngayogweba angibambe amaphoyisa ngabanjwa, mase bafika enkantolo mangabe bona badecide ukungi-charge ngekuweba bangangi-charge nge-trespassing, angeke bese kusasa bayabuya bavusa lona lecala ukuthi by the way leli angasimbopha kwekuthi beka-trespasse ne-trespass. No, ngoba bone mabaye enkantolo bayofaka icala bam-include anga-trespassing is not my problem, so ngeke kumcoka ukuthi mangabe bambopha umumfu bamfunzele lama unless vele kutaba licala lelinye, but nakhona I think it would be very difficult ukuthi kube licala lelinye mangabe bese bangi-acquittile or sengi-convicted. Bangamane balivuse lelo cala lelo before kuphume isigwebo. Anywho, a person shall not be tried for a criminal offense where that person has been pardoned for that offense. Masophardonishiwe nje bazalwane sophardonishiwe. A person who is tried for a criminal offense shall not be compelled to give evidence at the trial. Ngeke bese bathi angifakazi noma nginikede i-evidence kani kuboshwe mina, I'm not compelled to kunikeda bufakazi. Ngeke nje bese i-prosecution ithi sesitawubita i-witness sitawubita mine ngoba ngimle ngadigangela, so bangibese bayangi-cross-examine ngikuthi unless mine part of my defense I would choose to take the witness box. then that would be between me nenani ne-legal representative yami. I would say a prosecutor saying angifostele. Any court or other educating authority prescribed by law for the determination of the existence or extent of any civil rights or obligation shall be established by law and shall be independent and impartial, and where proceedings for such a determination are instituted by any person before such a court or other educating authority, the case shall be given a fair hearing within reasonable time. All proceedings in every court and educating authority shall be held in public, notwithstanding the provisions of subsection 11, which is the previous one, and it has to be held in public. A court or educating authority may, unless it is otherwise provided by Act of Parliament, exclude from its proceedings persons other than the parties and their legal representatives to such extent as the court may consider in circumstances where publicity may unduly prejudice the interest of the defense, public safety, public order, justice, or public morality, or would prejudice the welfare of persons under the age of 18 years, or as the court may deem appropriate. So as much as, like, for instance, at the moment which is in public galleries, anyone can go in and sit, in line with the COVID rules, obviously, and watch my proceedings. But ingandolo, if long as you say for the public safety or whatever reason, as long as it is reasonably justified, they can then decide, because they will have the proceedings behind closed doors. That's why they always say that when you're in Ngandolo, it's important that you behave appropriately. Otherwise, you might end up losing number privileges like your born. Or interculatory proceedings, I think, is to do with, again, bambana labancane kanzusi umfana 10 uhlukwethu umfana about 6 years. So such cases, they could be held behind closed doors. Shall, where it is so prescribed by law that is reasonably required in the interest of defense, public safety, public order, justice, public morality, and welfare of persons under the age of 18, or the protection of private lives of the persons concerned in the proceedings, excluded from its proceedings persons other than the parties and their legal representative to such an extent as it is so prescribed. So to protect those that are still considered minors, or a right to private life. So there needs to be a balance. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravening of subsection 2A, to the extent that the law in question imposes upon any person charged with a criminal offense the burden of providing particular facts. So la no 2A usho kona ukuthi nje ya innocent until proven guilty. Or subsection 2E, to the extent that the law in question prohibits legal representation before a Swazi court or before any Swazi court hearing appeals from such a court. That's E. So E utsene also permitted to present a defense before the court, either directly or legal representation. So if we are gandaba zabantu, you just have to appear on your own. Subsection 2F, or any other Swazi law and customs that court, you don't have to bring on. Subsection 2F, to the extent that the law in question imposes conditions that should be satisfied if witness is called to testify on behalf of an accused person, are to be paid their expense out of public funds. Sisibone F ukhuluma ngani, or would say the defense should be afforded facilities to examine the person or by a legal representation, the witness called by the prosecution. Shokuthi bangakuniketa lama-facilities but ngeke taba nema-limitations ngeke bese baphinze kufanele kukhokhwe timali tekugibetisa labo bantfu labo. You know, same kuthi mina mangabe nje bangibophile i-witness yami sengithi ngifuna ite bese ngithi uhulumende akangibhadalele ukuthi bete batongwitnessela. No, that cannot happen. Subsection 7, to the extent that the law in question authorizes a court to try a member of a disciplined force for a criminal offense, notwithstanding any trial and conviction or acquittal of that member under the disciplinary law of that force. So, however, that any court so trying and convicting that member shall, in sentencing that member to any punishment, take into account any punishment awarded under the disciplinary law. So mabe nje for instance isotsha balibopha mabe bese bavelele emasotsheni bake bamdisciplinela whatever that offense, let's say drink driving, mase yavela enkantolo kufanele inkantolo iku-akhawunte lokuthi emsebentini sebake bampanisha. So le punishment labatamnetayo nenkantolo kufanele babuke ukuthi ifake nalena lebese yavele ayisevile or layisevako ngale masotsheni. That's an example. In the case of a person who is held in lawful detention, the provisions of subsection 1 to E and F and 3 shall not apply in relation to the trial of that person for a criminal offense under the law regulating the discipline of persons held in such detention. So section 1 uthi should be given a fair trial. Shows nje, you know, by I think it is where maybe umumfu so mentally disturbed, for instance, without good detention, so they might not, you know, obviously have that kind of like a fair trial ukuthi bangavela nasenkantolo ngeba khona nokuthi maybe ba-examine witness blah blah blah. So loko kuya-accounta for, you know, and nalo ukuthi-ke law section 3 lokuthi they cannot give you consent obviously to be represented or ukuthi bona babe off kuleyo hearing yabo. So that's it really, they have been detained lawfully, so that's why they cannot come in. In this section, criminal offense, so for section 3, criminal offense means a criminal offense under the law of Eswatini and proceedings in relation to a court and adjudicating authority includes the announcement